Our third speaker is Ed Mitchell, and as I said before, we are very grateful that he's helping us and is very experienced in terms of union matters, and he's advising us also for the bargaining.
Thank you, Adriana. Just to give you a little of my background, I became a UFF member on my first day of employment at Hillsborough Community College in 1988. I've served as a UFF senator, vice president of the bargaining council, first vice president statewide, and executive director up in Tallahassee. So I have a very strong interest in the legal issues that we have to go through. To give you some background of what's going on right now, we had a case in federal court. It was filed in the Northern District, which is in Gainesville, challenging Senate Bill 256. That's the one that banned payroll dues deductions for education unions only. It also required 60% membership for education unions only. And it also had required language that we had to put on union cards. All of this was only targeted at education unions. It specifically exempted police unions, fire unions, and correctional officers. So it was very discriminatory in who it did. Unfortunately, the federal judge was not persuaded by any of our arguments and said no harm done and dismissed our case. We had a second federal case, which was also going on, and we ended up with a judge that people felt was not going to be a very good ear on our case. And so that case was dismissed voluntarily by UFF and FEA. The only other case that we have currently going in court is we have a state court case, which is being heard by a judge up in Tallahassee in the circuit court. And that involves the United Faculty of Florida, New College of Florida versus the Board of Trustees and the BOG. And that particular case, so far we've only had one hearing, and that was a motion to dismiss by the BOG and the BOT. The BOT motion to dismiss was denied, and the BOG is still pending. And basically, what both were saying is that they weren't the employer, which is nonsense. Clearly, the BOT was. They also tried to argue that the contract wasn't valid because of the date or something. But anyway, we knocked that down. So the big question now is what are the other issues we're going to raise in that, because that's where we're challenging Senate Bill 266, which is the arbitration ban and PTR. So we have 0 federal cases going on right now, and we only have the one state court case in Tallahassee. However, in front of the Public Employee Relations Commission, called PERC, we have what we call unfair labor practice, which is when the union charges that the employer did something that violates either the law or a PERC decision previous to that. So we have 3 cases that are going on right now. We have one case involving the University of Central Florida. In that particular case, they already conducted their evidentiary hearing, and the hearing officer, who is what's called an administrative law judge, who is an employee of PERC, so they're appointed by PERC, and obviously all appointees are basically political appointees. So that hearing officer heard the case at UCF and issued what's called a hearing officer's recommended order. So at this point, that was done this past a week ago. At this point, both sides have 15 days to file exceptions to that. And hopefully UFF, FEA, AFT attorneys will file strong exceptions to some of the conclusions that were made in that case. And if you want to see the hearing officer's recommended order, you can go to the PERC website and look it up, or you could send an email message to me or any of the other officers. They all have it, and we would be happy to send that to you. We have a USF ULP pending. We had 2 faculty members at USF. Both had been here for more than 10 years that were terminated when their program was, a language program was terminated, and they were not offered the protections under the contract, which both of them were entitled to 1 year's notice and an opportunity to look for other employment within the university. Not only did the university not comply with the contract, but because they don't feel that they have to go to arbitration, they basically said, we're not going to do that either. So both of those issues are pending in front of that. We also have an FSU case, again, challenging 266, all the same issues. That case was already heard by the hearing officer, so we're now waiting to see the hearing officer's recommended order. So moving forward, what do we need from the affiliates. In other words, what do we need from UFF in Tallahassee, the FEA, the NEA, and the AFT, all of the organizations that you have paid literally millions and millions of dollars in dues to? And what we need at this point is an aggressive defense of not only union rights, but faculty rights. I don't know how many of you were around 20 some years ago when Betty Castor was president and decided to retire. We had a senator from St. Petersburg who decided he wanted to be the next USF president. At that time, the SUS was governed by what was called the Board of Regents. The Board of Regents didn't even interview him for the job. So he got pissed off and he went back to the legislature and he got his buddies to abolish the Board of Regents. So without a Board of Regents, the question was who governed the state university system? So we basically went through a period of what I call chaos, where there was power grabs and everything else going on. But what it impacted us is immediately all the universities declared that our contract, our CBA, our collective bargaining agreement was null and void because they said that USF was no longer the successor employer to USF under the Board of Regents, despite the fact that there's 50 years of case law clearly establishing that. So we had to fight that. We fought that in the courts. We fought that in front of PERC. We did statement of interest cards. We got 90% of the faculty at USF to sign one, and we got the BOT to voluntarily recognize that UFF, USF was still around and we still had a contract. That's where we are again. So we're back to where we started. And what do we need? We need to litigate, litigate, litigate. Okay, the first step of that litigation is when we, as a result of the breakup of the Board of Regents and all the chaos that ensued, Bob Graham, our former governor and U.S. Senator, put forth an amendment to the Florida Constitution that created the Board of Governors. That amendment not only created the Board of Governors, but it divested the legislature of their powers over the state university system, with the exception of the power of the purse, the ability to appropriate funds. That's it. We've had at least 2 cases that have gone to the Florida Supreme Court that reaffirm that the SUS is governed by the BOG and not by the legislature. Unfortunately, apparently nobody has bothered to read that in Tallahassee, and we end up with the legislature thinking that they're in charge again. And so 266, the arbitration ban and the imposition of PTR are clearly violations of the Florida Constitution, and we need UFF, FEA, NEFT, and NEA to aggressively litigate that. We also need to challenge the BOG's authority over the SUS bargaining. In particular, when the Board of Governors was created, one of the first things that they did was establish what are the powers of the boards of trustees. In PERC, you have to establish who is the employer. So the BOG decided that all of the state university boards of trustees would be designated the employer for PERC purposes. That means we bargain our contract between the BOT and UFF, not the UFF and the BOG or anybody else. So we need to challenge the BOG's authority to, again, promulgate a rule that mandated PDR and abolished arbitration. The third item on the litigation scale there is that we need to challenge the state university system's BOT, in our case, the USF BOT, in mandating PTR and the arbitration ban. PTR is clearly an evaluation system. PERC has held that evaluation systems are what's called a mandatory subject of bargaining, which means that the BOT has to sit down at the bargaining table and bargain with UFF, the sole bargaining agent for the faculty, and come to an agreement. They can't simply impose it, which is what they did. Their argument at the ULP hearings has been, we're only following orders. But if you follow the logic that the legislature lacks the authority to impose and mandate PTR, and that the BOG lacks the authority to do that, then clearly the boards of trustees have violated law in Florida and our collective bargaining agreement. So we need to push. If you're a UFF senator and you're going to the meetings starting tomorrow and Saturday, you need to ask these questions and ask what's going on, who is litigating, where are these cases? Because if we don't fight for our rights, we won't have these rights. And I look forward to your Q&A when we get to that point.
Thank you, Ed. Our next speaker is Richard Manning. He is a professor in the philosophy department. He will explain issues related with PTR tenure and the bargaining process.
Hi, everybody. Richard Manning, Associate Professor in Philosophy. I'm also the co-chair of the bargaining committee for the USF chapter of UFF. I'm a UFF senator, and I'm also an executive member of the executive committee of the Faculty Senate. So what I want to do is I want to give a little presentation so that you all, if you don't know, which many of you probably do, know exactly what the difference between tenure as we had it and tenure as post-tenure review would have us have, what exactly that difference is, as a way not only of letting you know what's happening to your rights, but also as a way of illustrating the difference between what you get if you have collective bargaining and what you get if you don't, or matters of importance to you are imposed by the other side. Okay, here's what tenure and post-tenure evaluation look like when they're secured through a contract bargained by this chapter of the union. Article 15.9 defines tenure in this way. Tenure guarantees annual reappointment for the academic year until voluntary resignation, retirement, removal for just cause in accordance with the provisions of the article regarding disciplinary action, job abandonment, or layoff, etc. Okay, so what's just cause? That's defined in Article 16. Just cause is incompetence or misconduct. Any discipline, including termination for a finding of incompetence or misconduct, is subject to the grievance process outlined in the CBA, which terminates, according to the CBA, in arbitration by a neutral arbiter. Now, you may not have known this. It may surprise some of you. The CBA already has post-tenure review. It's called sustained performance evaluation. It holds, or it provides, that every 8 years post-tenure, you'll be evaluated. Only faculty employees are allowed to develop the applicable procedures. So administrators and the like are not the ones who say how sustained performance evaluation is run on the agreement that we negotiated with the university. Moreover, peer participation, that means other faculty employees, peer participation is required at every level of the process. The only basis for the sustained performance evaluation is employee annual evaluations. Employees who receive satisfactory annual evaluations will not receive lower than satisfactory sustained performance evaluation. So if you've been being told that your work is satisfactory over the past 8 years in your annual evaluations, you're fine. They can't give you a disciplinary finding of any sort. And moreover, employees who feel the process has been improperly conducted can grieve and ultimately, again, be heard by a neutral arbitrator. So that's what tenure means and what post-tenure review looks like when the UFF, USF chapter bargains to establish your rights. So all of that and a great deal more in the collective bargaining agreement protects job security, but also academic freedom. And in particular, the collective bargaining agreement protects faculty from discipline or termination on political or personal grounds, or because their area of research and teaching is no longer viewed as worthwhile by the university. Okay? Now, here's what it looks like when tenure and post-tenure are imposed by the legislature, the Board of Governors, the Board of Trustees, and the university administration. Now, every faculty member is to go through a review process each 5 years after last promotion or review. You need to compile a packet, which is very much like a tenure file, although it does not include outside letters of evaluation from experts in your field, so you can't get experts to support your claims that your work is good, et cetera, et cetera. And moreover, criteria of evaluation go beyond the areas in your assignment that are subject of annual evaluation. So it's not just research, teaching, and service. It also includes, are you conforming with state law, including state laws that control academic speech? Do you have a good history of professional conduct? Itself undefined. What's that? And other relevant measures of faculty conduct. Looks like you could put a whole lot of things in there and it's ill-defined. Now, there are 4 possible outcomes in terms of ranks that you can be given, ratings you can be given in PTR. 2 of the 4 of them result in discipline. One of those results in immediate termination, right? You're done, but you do have a 1-year non-renewal period to not be broke, okay? The other results in the issuance of a performance improvement plan, which gives you at most 1 year to shape up. And if you don't, then you're done. And we all know what it's like trying to publish a year's time frame to, for example, get a research program, get some more publications. In many fields, that's completely unreasonable. Okay. Of course, satisfactory or even outstanding annual evaluations don't guarantee you will not get one of these disciplinary ratings on your PTR. The chief academic officer, that's the provost or a designee of the provost, issues the final binding ranking or rating. And this is not controlled by previous ratings of the chair or of the dean. The provost can modify, reverse, whatever, okay? Final decisions may be appealed, including under the provisions of the CBA, if applicable. But now remember, the legislature has eliminated arbitration for these sorts of matters, or is trying to. So for that reason, the decision whether the university violated its own regulation in a PTR determination rests with the university. Hey, university, did you violate your process in firing me? No. What are they going to say? Okay. It's the mark of tenure that whether you earn it or not is up to the chief academic officer. That's always been the case with tenure decisions. But once you have it, whether you keep it is not up to the chief academic officer, short of a sustainable showing of just cause. So I think every one of us who's tenured or on a tenure track, and I know that we're not all tenure track employees, and I'm telling you these things as an illustration of the difference between what you get when you bargain and what you get when you don't, right? Every one of us who's tenured or on a tenure track, right? We don't have tenure. It's just a lie that we have tenure, okay? People who are on a tenure track have lost the opportunity to get tenure. They're getting something else instead. Those of us who have earned tenure, we don't have it anymore. All right, so what about grieving post-tenure review? Unlike sustained performance evaluation, at this time, post-tenure review is not a part of the CBA that regulates your terms of employment. And for that reason, we cannot file grievances to enforce PTR. That is to say, to make sure that PTR has been followed properly. However, as the imposition of PTR itself violates the CBA in a wide variety of ways, including altering your assignments without your written consent, right? We can grieve certain actions taken in the course of implementing PTR. So you can't come to us and say, I want to grieve this because they didn't do what they said they were going to do in post-tenure review. That we can't do. But if you come and say, I want to grieve this because because I had to do a whole lot of work to put together my post-tenure review packet and it's not reflected in my assignment, so they altered my assignment without my consent, then that's grievable. At least it's up for the grievance committee to determine whether that is a grievance worth following up on. Okay, for this reason, and also because there's going to be a lot of cleanup to do if and when PTR is struck down as unconstitutional, which I firmly believe it is, we advise you, document everything you do in the course of complying with the PTR implementation. Don't rob yourself of the kind of record that you may need to use in support of a grievance. So we are fighting post-tenure review and the abortion ban and a lot of other stuff at PERC and in the courts. For the rest of bargaining, we're fully prepared to listen to any administration proposals, and we will respond to these in the best interest of all our faculty, tenure stream, and other, in a process that we aim to make as open and transparent as possible, and in which we plan to solicit broad input about what is important to you. We're also in the process of generating bargaining proposals of our own, again, based on faculty input and with the interests of faculty in mind. But, and here's the payoff and the ask, we can't do any of this if we don't exist. If we're decertified, you lose your right to collective bargaining, and you are on your own trying to secure and enforce rights as an employee. And as the administration's complete refusal to resist post-tenure review, for example, and the arbitration ban in any serious way suggests, you're not going to do too well on your own anyway. Good luck with that. So sign the statement of interest cards and join the union. Okay, thanks.